on to amendments to other laws, and we will first cover the changes in indirect tax, GST, and custom. We have with us Jatin Christopher, a chartered accountant, cost accountant, a law graduate qualified in 1996, and specializes in indirect tax laws. Jatin is a published author and a resource person for ICAI in its various post-qualification programs on indirect taxation. He supports ICAI in publishing educational and research material on indirect tax topics and is also a resource person for the government, conducting training for practitioners, trade, and officers. Jatin has been practiced since 2000 as a partner in JCSS, a full service firm with a presence across India. A warm welcome to you, Jatin.
Thank you.
So, how are you?
Very well, thank you. Been a wonderful
So, here
budget.
we meet again for the budget marathon.
Yes, thank you.
So, great. So, now the session is yours to lead. Please take it forward.
Thank you very much. Good evening, friends. I recognize that participants have been sitting in on this marathon presentation organized by Taxmann, and it's something that's very put together very quickly and very opportune to bring key issues to participants' attention that the fine print in the budget document reveals. Speaking about customs and GST, there are certain significant amendments proposed in this law. Many of the amendments, particularly in GST, was anticipated, but what we were looking forward to was the exact construct of the language in the bill. And as we see this bill move forward into a legislation, we will see there are some areas, perhaps there could be some tweaking of the language to carry the address any gaps between what was the decision and what's the language employed. But otherwise, we see a lot of value in the bill provisions that we need to take away from this marathon that Taxmann has put together. We'll quickly get into some of the provisions on customs law. The purpose is not to take participants through all the various clauses in the bill, but to bring to your attention certain key aspects. Of course, the question of certificate of origin, we can't miss. It's something that brings a lot of clarity by introducing some of these requirements within the statute itself. So the proof of origin has now found a specific and clarified definition in the statute. So complex transactions which were left to be determined based on international practices have now been aligned with the way domestic law looks at proof of origin and admits proof of origin. This opens up new possibilities for a lot of merchanting trade transactions reaching India, although they may origin, the origin of that supply the import may be from a specified jurisdiction. Even if it flows through a intermediate jurisdiction, it will still be entitled to the concession that we see under the preferential tariff agreements that India has with several countries. This also opens up the possibility for us to be very cautious as we claim concessional tariff on imports by examining how do we establish the basis to secure proof of origin. Now, there is also this added peril that there could be, there's a demand for transparency of gross margins if intermediaries are involved and the shipment is from a preferential tariff jurisdiction, but the transaction is with an entity located in a different jurisdiction. So that is something that jumps out of the pages that we will need to take note of. And as we find specific applications, this will sort of give us some work to do before we determine that preferential tariff is not at risk in certain transactions. Looking at some innocuous but important amendment is in section 65. As we know, warehousing has got a lot of attention, perhaps in the last 10 years, where a lot of in the name of allowing ease of doing business, we've seen a lot of change in section 65 for many years. Manufacturing operations in bonded warehouse was quite free from action, but suddenly we find that there is no such there have been too many changes that has come in, and yeah, Ridhima, this the deliberations will not have any PPT to share, but we're going through the various clauses only. I'm only keen on sharing the implications of this. All right.
Okay, great. Please go ahead.
All right. So for many years, we've not seen any change in the provisions relating to the rules under Section 65, but we find profound changes coming in the last 10 years to ease doing business. Now we've seen mover regulations also come in. Now we find restrictions flowing in by government deriving power to specify what activities are not permitted in a warehouse. For those who are involved in mover operations, it's very significant that government has sort of created an enabling proposed to create an enabling provision in Section 65 for the government to notify what will and will not form part of operations permitted in a bonded warehouse, whether it's a private warehouse or a public warehouse. This is something that is of significance for us to, at least for many years, we've worked with companies setting up bonded warehouses and carrying out operations in that, even without being an EOU, that we find that this amendment, although so innocuous, can be very significant as we go forward. We'll quickly jump to the GST amendments given in the interest of time. Clearly, we see ENA issue being addressed straight away in Section 9. So ENA is going to be addressed and kept out of the scope here. So therefore, the doubt that existed has been addressed. But significant it is that when there is an amendment in Section 9 that requires ENA, an amendment that was required to keep ENA out of the incidence of tax, this amendment obviously is going to have a bearing as far as its effective date. And if it is effective prospectively, what happens to the incidence of tax for the past, that requires some redressal. Directly on this point, we thought that Section 11A, I'll tell you in a moment about what is 11A. Section 11A that has been inserted, proposed to be inserted in the statute through this budget proposals, can bring in a lot of relief from a legislative inflexibility point of view. What do I mean by legislative inflexibility? If you see Section 9 or 11 and several other provisions, the cooperative federalism principle took away a large amount of flexibility in lawmaking that the government had exercised in the earlier tax regime. We find progressively a lot of those restrictions where prior concurrence of the GST Council was necessary before moving any amendment or issuing any notification or prescribing any rules. In several significant places, that is being diluted. But I would also like to mention that this dilution is very cautious, to see that as long as the decisions taken by the council are, the government is able to effectively implement those, in such areas the inflexibilities are being taken away. And Section 11A is one such provision where, if it has been a custom in the trade that taxpayers have historically not paid GST, or where GST has been paid at a lower rate than what the language of the legislation requires, power is now vested in the government to notify that for the past, the liability will be extinguished. That is significant because taxpayers have seen in the last several GST Council meetings where what's dubbed as the as-is circular. Circulars are issued under 168 perhaps to resolve disputes on as-is basis. That is to say, wherever taxpayers have paid the tax, no refunds will be granted, but wherever taxes have not been paid or paid at a lower rate, no further disputes will be raised by the revenue. So if you look at this approach, it seemed to be that it had become commonplace. Today we find a very solid legislative framework being put in place through Section 11A. And we will find that this Section 11A can be put to use in many instances. Past liability for ENA could be one case. Gaming disputes could be another. There are many instances that come to mind to see where Section 11A can be put to use. But yeah, after 9, the amendment proposed by introduction of the Section 11A is quite significant. Another aspect to consider is that, again, seems very innocuous, nothing to be anxious about, but the language here in the provision can have profound implications. I'll touch upon two amendments that are proposed. One is in Section 13(3)(c), along with the amendment proposed in 31(3)(f). If you see here, as regards reverse charge liability, time of supply provisions were left to two criteria. Now a criteria regarding the issuance of self-invoice is proposed to be made mandatory. So time of supply in respect of reverse charge liability of services is now finding a place in 13(3)(c), read with 31(3)(f), which specifies that the self-invoice that should be issued, it also says it should be issued within the time prescribed. Please bear in mind Rule 48(5), which says where e-invoice is applicable, but such an invoice has not been issued, or a manual invoice has been issued, such an invoice will be non-est in law. That's what 48(5) seeks to accomplish. So when there is a manual invoice issued, when e-invoice was applicable, that manual invoice will be non-est in law. If you consider that experience and read it in the context of 31(3)(f) having a time limit to be prescribed, let's see what is the time limit that is likely to be prescribed. Prescribed, as you know, it's going to be prescribed in the rules. So another amendment to the rules is in the offing. Clearly, the amendment will come in after the law comes into force. When will the budget proposals be notified? Not only should the Central Act be passed by the lower house, upper house, and assented by the president, but in order for the Central Act to be notified, all states also must amend their state legislations in a mirror fashion, and on one fine day, both legislations, because GST is a dual tax, both legislations will be notified, which means we're looking at a good few months away for these proposals to take effect, and it's only after that that we will have a notification under 31(3)(f). What does that do? 31(3)(f) along with 13(3)(c) amendment, keeping in mind 16(4) can wreak havoc as far as RCM liability is concerned. Today we have a circular number 211 that says past liability for RCM can be discharged presently along with interest, and there won't be any bar on credits. Speaking about 16(4), straight away the language of 16(4) does not accommodate RCM or import payments. However, through this circular, some teeth is sought to be given for RCM to also get covered by 16(4). So that itself will be a bone of contention. But if we move from there to look at what 13(3)(c) and 31(3)(f) amendment read with 16(4) can cause, it can only bring in a outer limit for belated returns. What does it mean? With circular 211, self-invoice can be issued belatedly and taxes discharged along with interest. Credit will not be restricted. But today, but tomorrow, when all these amendments are in place, and if the time limit to be notified is in line with 16(4), we will find that the last date to issue a self-invoice also will be November 30. When the last date to issue self-invoice is November 30, RCM tax will be recovered subsequently, because RCM liability cannot be forgiven just because self-invoice was not issued. But RCM discharge subsequent to November 30, the self-invoice may find that we may find that self-invoice issued after November 30 is non-est in law. So then we will find that the recipient will not be entitled to credit for defaulting on 16(2)(a). I'll just leave these four provisions on the table for you to please contemplate on that and consider the profoundness of the implications we see coming in through these two amendments in Section 13 and Section 31 of CGST law. The next amendment we will look at, of course, we have to talk about 16(4). 16(4) relief has not been as elegant as I would have liked to see. I'll tell you why. 16.4 clearly deals not with belated returns, but with stale credits. Invoices that have been omitted in spite of returns having been filed is what 16.4 should cover. But returns filed belatedly with late fee enjoy curative effect on payment of late fee. But this amendment seeks to disturb that meaning that is emerging plainly from the language of the law as it currently exists. What is this amendment that is proposed? This amendment proposed basically says that if anyone has filed returns belatedly, but not later than 30th November 2021, any delay in filing returns and consequently forfeiting credit, that credit will now be admitted as valid and proper. Three situations exist today. Taxpayers who have got notices and have paid the credit, have reversed the credit or discharged that liability along with interest and or with penalty. Situation where taxpayers are currently dealing with notices, and situation where taxpayers are in appeal in respect of these notices. In all three situations, remedy is available only for case 2 and 3. Remedy in the first case is not available because anyone who has discharged the tax cannot be refunded any amount of money that they have discharged. Please bear in mind, you cannot claim refund in the context of 16.4 is different from the context of 128A, which I will come to in a moment. Please be mindful. If 16.4 recognizes that credits claimed within 30th November 21 is valid and proper, and someone has discharged this tax, option to file refund cannot be ruled out. So taxpayers who have discharged the tax, that is use case number 1, taxpayers are advised to please evaluate the feasibility of filing refund, because 16.4 relief that is provided in 16.5 is not lost, unlike the relief that is sought to be introduced via section 128A, which I will discuss in the later part of this evening's deliberation. Next, another important aspect. I'm only sensing that this is first of several. Section 16.6 sees a proposal where taxpayers whose registration was cancelled and on account of cancellation could not file returns and therefore were hit by 16.4, when their registration is restored, in such cases, if they were to file all outstanding returns within 30 days from restoration of registration, they will not be denied any credit in terms of section 16.4. Two aspects to consider. One, 16.6 should have commenced with a non-obstant clause because it operates as a proviso to 16.4 and not as a standalone subsection. So in the construct, there is some refinement that may be warranted. Secondly, if 16.6 is in fact a exception to 16.4, what about 8 or 9 other exceptions that are required? I'll give you one example and I will move on in the interest of time. Clubs and associations were made liable to tax only and only because of an amendment introduced in 71AA, effective 1/7/17, notified 1/1/22. So therefore, 54 months of credits need to be claimed by these clubs and associations when they file their first returns. Will they be hit by 16.4? It cannot be, because credit cannot be denied, because the incidence of tax on clubs and association comes up only because of a retrospective amendment. Where is the corresponding saving clause in 16.4? So like this, there are other 7 or 8 more exceptions that merit to be introduced in section 16. So we only have to find that the government has very gracefully accepted the need for 16.6. We are very thankful for that. We need 7 or 8 more such exceptions to be created. This goes only to show that 16.4 is now going to operate as what's called an extinguishing prescription. Very quickly, what is limitation? What is prescription? Limitation takes the remedy, but leaves the right undisturbed. Prescription takes away the right itself. So therefore, this debate about vested and indefeasible right versus concession, etc., needs to be resolved. But there's a lot of work in section 16. I'll bring your attention also to another amendment in section 30 that is proposed, very innocuous, easily overlooked when we are going through the proposals in the bill. But section 30 is very significant because revocation of cancellation is now made subject to conditions to be prescribed. So please bear in mind, someone's registration may be revoked. Someone's registration may be revoked. Revocation is not done in appeal. Revocation is done by the proper officer. When revocation is being done, new conditions are sought to be introduced. What could be those conditions? Section 16(6) could become one of those conditions. If someone wants revocation, please be very vigilant. I'll give you another aspect to consider. Registration that is cancelled without going for revocation, can someone file an appeal for restoration? Please consider this possibility. If you go back to the proper officer for revocation of cancellation, you're hit by the condition in section 30 to be introduced. But if you bypass revocation and go to appeal for restoration, you might be saved by the operation of section 16(6). Please consider that as you evaluate the possibilities that can come because of that. A brand new section 74A. I will go into what 74A is in just a moment, but consequential amendments, when I saw the list of sections that have been touched by the finance bill and saw 61, 65, 66, the entire chapter being touched, I was immediately drawn to looking at what the bill provisions contain. But the only amendments that we see in the whole of that chapter deals with including reference to section 74A, wherever references were limited to 73 or 74. So now to look at some of these related references, we'll talk about some of the key amendments that are being proposed related to section 70. 70, as you know, friends, is a power to issue summons. Let me also bring this to your consideration. Please read section 70, subsection 1. The authorization referred to in subsection 1 of 70 does not have a rule or a form in the statute. Please consider that 70 is an aid to 67. So INS 1 and INS 1 alone is the authorization for proper officer to issue summons. The two remarkable things I find here. One is that a new subsection 1A is sought to be introduced in section 70 to say, when a person is summoned, the person is bound to appear. Remarkable for the reason as if when a person was summoned, he had a choice not to appear. Secondly, 1A proposes to permit an authorized person to enter appearance when summons is given to a different person. This greatly dilutes the severity, seriousness, and importance of summons. Summons have to be attended by the very specific person. As you know, different people have had different experiences, but in many parts of the country, summons have been issued without any authorization. And when you question the correctness of the authorization, you found that those investigations were abandoned. So please consider section 70 with some amount of discernment, because nothing new can be achieved by introducing certain severe language in subsection 1A to section 70. The next aspect to consider is the whole construct of 74A, 74A requires very careful study. Very quickly, if I have to bring to your attention what is 74, no new jurisprudence. I've spent a lot of time trying to update the publication of Taxmann quickly based on this new section. No new jurisprudence. The only aspect that comes up is that time limit under 73 was 3 years, under 74, 5 years. Time limit under 74A is now 42 months to issue notice, 12 months to pass an order, that's 54 months, 6 months extension permitted for passing this order for sufficient cause, which means 60 months becomes the limitation, and we'll have to only contend with that. The whole of the safeguards for taxpayer in section 75 applicable under 73-74 has remained undisturbed. Please pay attention. 73-74 will stop being used if the demand pertains to 24-25 or later, which means for the next 4 or 5 years from today, 73-74 will continue to be in force. We have to continue to expect notices under 73-74 for the next several years before 74A starts to take effect. Moving on from there, important reference, definition of suppression in 74 is at the end of section 74 is sought to be omitted, and a new section's definition is sought to be introduced at the end of section 74A. Remarkable change in the language, but no new jurisprudence, because the safeguard is that even if that were to be considered suppression in the new definition, evasion of tax still has to be discharged to established by revenue. Moving on very quickly to other amendments. GST Appellate Tribunal, a lot of attention, a lot of refinement in the language, because GST Appellate Tribunal is around the corner. We can see it take shape in the next few months. Anti-profiteering orders are set to be left with the principal bench of the tribunal for adjudication. It is remarkable that adjudication is now going to be with the second appellate forum in GST. A lot of questions as to whether this is the right forum, because there's a very long-standing principle called the Leary principle. When a taxpayer has a right to fair trial and a right to appeal, taxpayer cannot be expected to make do with a fair appeal without an adequate adjudication process. Here, adjudication itself is left with the second appellate forum, so there's going to be questions surrounding the validity of this. Tribunal, what is the limitation? Previously, we had seen tribunal to be notified and president to enter office, 3 months limitation to commence from that date, but now it is the time to file the appeal is extended by 3 months or the date notified by the government, whichever is later. So there is going to be a reprieve. Limits of upper limits for pre-deposit reduced marginally from 25 crores to 20 crores each. I say marginally because those who have such significant demands don't find this reduction very significant. But what is significant is that the additional deposit of 20% in the tribunal has been reduced to 10%. So please consider a significant amendment made in Rule 142(2)(b). This rule has already been notified by 12/2024 notification, 10th July 24. Please see Circular 224 makes it mandatory for all those who have made pre-deposits in first appeal, waiting for second appeal due to recovery action, made payment due to court direction, for whatever reason, please read Circular 224 regarding the procedure under 142(2)(b) made applicable for all pre-deposits made via DRC3. Please bear in mind, this circular further goes on to say that awaiting the tribunal's decision, tribunal's constitution, taxpayers need to do 2 things. First, give an undertaking to the proper officer that you wish to prefer appeal before the tribunal to make pre-deposit. How do you make pre-deposit? There's a process specified in the circular. It's not DRC3, mind you. It's directly go into the services module of the portal and make this deposit to declare your intention. It's an affirmative action that you wish to carry the matter in appeal. Amendments have been made consequent to these changes in IGST law and the compensation cess law to make provision for similar to 11A in the Central GST Act. So please bear in mind, profound changes, very, very significant long-term implications, many of them to refine the due process, bring small changes, but significant in the bearing that it can have as far as how this needs to be done. Interest provisions, multiple effects being given to these provisions. Please be very, please give it the time needed to go through these amendments, because the implications of this can be very profound as we wait for the budget proposals to get enacted. And that is going to be very interesting before these new provisions take effect. Over to you, Ridhima.
Okay. Thank you very much, Jatin. This was much anticipated and in-depth analysis. Just give me a moment while I take few queries, if you allow me.
Yes, please.
Just 1 second. So this first coming up is, I'll take quickly 2-3 of them. Can the taxpayer take the benefit of waiver under Section 128A for SCM in DRC 1 for the first year and go to appeal for same matter raised in statement in DRC 2 for another financial year?
Absolutely, absolutely possible. Every notice is the boundaries of the list. Taxpayer is welcome to pursue whatever remedy she feels serves her interests best in a given matter.
Okay, great. And another one is pretty interesting on Section 128 only. So Section 128 provides that the benefit of waiver would be available only where any tax is payable by the person. So in case where the demand is of interest or penalty is there, would it be covered under this section? If not, would it not be unfair for such taxpayer who has paid tax and only interest was not paid?
Every dispute resolution scheme in the statute by way of policy is bound to be unfair to somebody or the other. We cannot expect equity in a dispute resolution scheme proposed by the government.
Can they take a plea that the benefit is not available? Can't they do that?
Absolutely, no question about it.
Okay. Any other important query? Just 1 second.
And mind you, on 128A, if the revenue were to carry the matter in appeal or revision and an additional amount becomes payable, that too will be payable. So therefore, 128 relief has to be pursued with a lot of care and attention. It cannot be something that can be blindly followed just because it brings an end to litigation.
Correct, correct. Just last one of the lot. So in the amendment made in Section 17, subsection 5, to remove restriction of ITC on tax paid under Section 74, what is the purpose of adding the year 23-24 specifically? Because as Section 74 itself is restricted till financial year 23-24. This effect would have been automatic, right?
I suppose we have to pay attention to what will happen to the liability discharged through a demand under 74A. Please bear in mind, with 16.4 now firmly planted, with support of 16.6 and 16.5 and 6 inserted, as far as the interpretation goes, it is very clearly possible that all demands which are not discharged, all liability that are discharged, whether whenever it's pursuant to notice of demand, credit will be lost. Particularly with the amendments to 13.3C and 31.3F, RCM is the one of interest in 17.5I, credits will still be lost.
Correct. And one I think is in the Zoom chat box here. We have paid taxes, filed appeal for interest and penalty. Can we avail them next week?
Yes, yes, of course, of course. The requirement is that that has to be withdrawn, and 128A permits bringing quietus to this dispute by discharging the liability and withdrawing the appeal.
Okay. Sorry, one more coming in. If the time to file the appeal before tribunal has not expired, can the department initiate query recovery?
Absolutely. Please follow Circular 224. Make the pre-deposit, file the undertaking. Even if someone is planning to take the relief under 128A, please bear in mind 128A is only a bill proposal. It's not yet law. File your appeal. Keep the matter alive. The vaccination is on the way. Please look after all patients.
Amazing. Thank you so much. Thank you so much, Jatin. It is a wonderful session indeed.
Thank you very much. Thank you very much.
Thank you.